Okay, I propose, with the blessing of the organizers, whom I thank really for inviting me to be the chair to this panel. I think it's been a really enriching day. So we will have our last panel, which is actually quite special because other than all the other panels of the program, also the ones tomorrow, this panel does not deal with a distinct area of international law, but it deals with interpretation in the law of sources. So I'm very happy to have a very distinguished panel. I'm going to give them the floor in turn, as it has been done. So we will start first with my dear colleague from Amsterdam, Professor Brölmann. She's also my colleague in the advisory committee on international law. I think she's the expert in the Dutch scene on all the foundational issues of international law, responsibility, law of international organizations, lawmaking. So I think very well placed to kick off our panel. And she will speak about rules of interpretation in an institutional context. Kiki, the floor is yours.
Thanks so much. Let me look at the time, but you will nudge me.
I will.
Okay. Thanks so much. And first of all, of course, to TRICI, which I find very difficult to say. TRICI, I would say. And Panos and Sotirios and the whole team for inviting me. In the spirit of the project, I will aim to speak of interpretation in institutional context. It is, of course, an established view that in an institutional context, more room seems to exist for object and purpose interpretation, for teleological interpretation, even evaluative living instrument interpretation of treaties, and notably constitutive treaties. And by institutional, in this case, I mean a formal, let's say, international organization. Now, why this is so? It's not entirely clear. So one hypothesis is that organizations have a vertical dynamic. So as was captured early on by the notion of centralization used by Kelsen for the UN. It could also be because each organization represents a single epistemic community or an interpretive community, even if that is, of course, not so simple. I think of the 3 UNs or the UN in Geneva and the UN in New York. Or it is the dynamic of sectoral constitutionalization, which is this nice notion that Anne Peters proposed. And even, but I won't go into that, as Justice Zjemele has indicated this morning, constitutionalized treaty regimes also give rise to the same kind of, this type of object and purpose interpretation. And of course, it all ties in with the functionality discourse that Jan Klabbers likes so much for good reasons when he speaks of international organizations. Now, the question that I ultimately would wish to pose, but I'm not sure it will be answered, in any case, not by me today, is whether the institutionalized environment that seems conducive to a teleological interpretation of treaties also has this effect on the interpretation of customary international law, which is formed in that environment in the same way. And then, of course, there is this thing Ilios Plakokephalos mentioned already. There is no teleological interpretation of custom because it would be a new rule of custom. So, and I see more people nodding. So that is something that halfway I also realized already before today, but still I would like to pose the question. Now, so I will just briefly, everything briefly, of course, elaborate on the picture of how it is with treaties, constitutive treaties mainly. Also because I've understood that so far the institutional perspective has not yet been prominent in the TRICI project. So why not? Nice information. I then briefly addressed the elusive possibility of international organizations themselves creating custom, which is tricky as it is, no pun intended, but really not. So these are 2 things that I've really looked into. And then in the third, now my notes have disappeared. The third thing is something that, as said, I haven't really found an answer to, and it requires much more research. So that's a pledge, maybe. And that is to see whether there's any indication in soft law in the context of the UN. So I thought, why not start with a nice General Assembly resolution like the Friendly Relations Declaration? But it didn't really go anywhere. So that at the end of my remaining 10 minutes is more like questions. Okay, so first the treaty interpretation in the context of organizations. To quote the WHO legality opinion, there is this passage, for example, where the court says the imperatives associated with the effective performance of the organization's functions, as well as its own practice, are all elements which may deserve special attention when the time comes to interpret these constitutive treaties, end of quote. Now, what kind of special attention do constitutive treaties receive? Traditionally, of course, if we follow Sinclair, who has already come up, who has passed in the talks of this morning already several times, treaty interpretation accords considerable weight to the aspect of consent underlying the treaty, and maybe together with an intentional approach, there's generally less concern for object and purpose, as Sinclair holds, and he issues a warning that it may give rise to undue teleological interpretation if people would look too much to the object and purpose. However, in contrast, the interpretation of constitutive treaties appears to have been generally inspired by the principle of effectiveness and by an approach which is en vogue also because of the many objective regimes that we now have, conceptually to separate the treaty from the regime that has then been created by it, which makes it all a bit easier. And to keep it short for this occasion, overall, we find two trends pardon, in the interpretation of constitutive treaties that stand apart from the standard VCLT approaches. And the first is the indeed teleological approach to the text, bit similar, you could say, to traditions in national law of statutory interpretation, constitutional interpretation, in an organic constitutional context. Think of the iconic reparation case, for example, which is really reasoned from that angle. And secondly, there is a particular, but I won't go into that otherwise, is a particular importance attached to the practice of the organization itself, interestingly. So as opposed to the practice of the original treaty parties. So there is already a kind of sorcerer's apprentice thing that the organization's own practice then is a tool in the interpretation of its constitutive treaty. Then for terminological distinction, maybe quickly, because also we heard already quite a bit also this morning about object and purpose. In my mind, the object and purpose approach is sometimes is to be taken as a separate thing and it's used to elucidate a textual approach, to discern the ordinary meaning to be given to a treaty's terms. So I think I've understood that this is not quite the same as a teleological approach, which in its classic sense is a general interpretive approach. So it's less text bound, written text bound, which makes it maybe more relevant for the context in which we are discussing. And then there's, of course, the evolutionary living instrument approach. And all three play a role in the interpretation of constitutive treaties, but the teleological approach is the most prominent, I would say. Maybe can I ask how much?
You have 10 minutes more.
Okay, then I'm totally, I'm going to say everything that I put in my notes. Okay, meanwhile, just also for maybe reference or possible analogies that we could make when it comes to IO's secondary law, so majority decision-making acts. So when we shift from the contractual to the institutional paradigm, you could say, in general, the interpretative practice seems to differ some from the practice relating to constitutive instruments. An additional principle is the contextual interpretation, which means that acts have to be interpreted in the context of the constitutive treaty. But also some scholars emphasize that contrary to the constitutive treaty, the interpretation, I'm now quoting, interpretation according to the object and purpose has to be referred to much more cautiously. And this is a result of the delegated character of secondary rules. So there already it has become, again, the connection with the treaty maker, since it is more distant, somehow people get more nervous of the idea of teleological interpretation, which is a common mechanism, I think. It's sort of communicating vessels. And indeed, no, this I'm going to leave out. So this is a first little mini picture of interpretation of constitutive treaties and slightly different secondary acts. Then a second thing that I want to propose to your attention briefly is the question, as I said, whether organizations can produce, so to speak, customary law to begin with. Why is this relevant? This is because if we do not really see IOs able to create custom, while UN General Assembly resolutions would be taken as an act of the organization rather than of the member states combined, then there would be a void. There would not even be an issue of interpretation because somehow there is no lawmaking. And in that respect, I wanted to share some observations about the 2018 ILC conclusions on the identification of customary international law. That they show actually that contemporary international law and doctrine, maybe not practice, but law and doctrine accords a really modest role to international organizations as independent actors in the formation of customary international law. And in my mind, it was quite remarkable, actually, given that international organizations participate really ever more fully in international affairs. And what that little bit of research brought me is that, in my mind, this is connected, among other things, to the factor of international law having reservations to ascribe this juridical will to international organizations. There is a certain the various subjective intentional states that legal systems use to project upon participants to operationalize legal agencies. So this is intention and will and acquiescence and all these psychological states that are really a construct used, that somehow nobody has had problems attributing this to states, even after the interbellum, when scholarship had sort of done away with anthropomorphic images and everything. But there is great reluctance to attribute this to international organizations. So I won't carry this too far, but there is, if you really put on those glasses and you look at the codification process of the Second Vienna Convention, for example, it is remarkable. You see it everywhere. This attempt to bring organizations on board as legal subjects, as participants, but then again, not quite the full works, not quite the personne morale, not so. So it's a very double-hearted approach, which law is not really able to accommodate, but that I think is one reason. This what I've called elsewhere the functional mechanistic identity in international law of international organizations is one reason why the ascertainment of an organization's opinio juris, for example, which is really which is this constructed, this projected mental state, is or any other will, is a challenge for international law somehow, for the international community. And if you look at the conclusions, they appear in two ways: international organizations as a platform for the acts of states, and as an independent legal actor, always this double-headedness. And for independent actorship, agency, you see basically only conclusion 4, requirement of practice, paragraph 2, to refer to the practice of organizations in their own right. And it's really reticent. And the commentary says this is most likely to occur it's most likely to occur when states have transferred exclusive competences to an international organization or conferred powers, etc. So they basically at this point in time, the EU situation. And more generally, the commentary and the conclusions, they really point to a key role for states, which is not strange, but it is a bit, it could have turned out a bit differently. So this, I'm just, it is a bit impressionistic, but I'm just adding this to it's another little picture. I'm adding it to the story because it does tell us something about how we look at who is the auctor intellectualis of a resolution in the General Assembly, which of course then has consequences. And also it also goes for acts in other international organizations. Now, then finally, as I said, now comes the part where I thought I would sort of easily come up with some cursory findings and then I would later type it up for the chapter. But a bit due to the end of term busyness at work, but also because it's much more complicated and I had not thought it through enough, I think. I don't have clear course here. So leaving the general trends in constitutive treaty interpretation, I would ask, how do non-binding and possibly custom-creating resolutions of the UN General Assembly, how do they fare? And as said, I thought I would look at the Friendly Relations Declaration because it has a respectable age and it has been confirmed in the Nicaragua decision and the Kosovo opinion that it is custom. So I thought, well, that must be my gold mine. And it will show signs of teleological interpretation. So indeed, my one hypothesis was that the customary norms and rules are subject to some sort of interpretation, the customary norms and rules that come from such a respectable UNGA resolution, and be it proxy textual interpretation or a logical interpretation. I'm now quoting, of course, a text by and paper by Panos, but still any kind of interpretation. And my second hypothesis was that such interpretation in some cases would show signs of teleological approach, similar to instances with regard to constitutive treaties. And this would then nicely fit the TRICI project. But this is where, and I'm almost at my conclusion here, this is where my findings, my cursory findings did not really point in that direction. So I thought maybe we will need to look for texts or resolutions where there's more of a public common sphere. Again, this dynamic of constitutionalization, maybe that is in this Friendly Relations Declaration, where people, as I understood it, from a nice entry by Helen Keller, a recent entry in the Max Planck, that people were even angry that the exceptions to the prohibition on the use of force were not mentioned. So it is actually, the topic is quite an old-fashioned sort of bilateralist thing in a way, although it was also, of course, a great communal statement. So maybe maybe I should have looked at the Universal Declaration or something of human rights, something different. Maybe Professor Tzanakopoulos will speak of Security Council resolution, which are of course binding, so that's a different story, but still maybe insofar as they give rise to custom, maybe that will shed light on it. Yeah, I think I will, I can brainstorm on a little bit, but I think I will leave it a bit at this, but I would be seriously very interested in hearing whether in your view this is in any way a promising track or really doomed to failure for a few sort of conceptual errors, such as maybe, as Ilias was saying, because teleological interpretation and just changing your conduct and creating new custom cannot exist at the same time. So yes, so thank you very much.
Thank you. Well, personally, I must say, I think it's a very promising avenue. In particular, yeah, I'm not, I'm just a panel chair, but in particular with the General Assembly's newfound role and going forward, actually, and with some of the resolutions that we, and I think many were discussing in the coffee break regarding Russia that have been issued already, but that are probably also upcoming. I think actually your question is very pertinent. Okay. So from the General Assembly, we're moving to the Security Council, which issues binding resolutions, but does it? I mean, maybe that's one of the questions. And well, who better to speak about that than Professor Tzanakopoulos, my dear friend Antonios, who wrote this really groundbreaking book on disobeying the Security Council. And I think that's also the source of inspiration for your talk to us today, which is on the interpretation of Security Council resolutions, in particular sanctions resolutions by domestic courts.
Thank you very much, Larissa. That's very kind. Also, of course, thanks to Panos and Sotiris for the invitation. It's a great pleasure to be here. And of course, my topic now, as you say, it's the General Assembly's newfound role. Absolutely. Perhaps my topic is now confined to the dustbin of history, or at least for the foreseeable future is only of historical significance, but oh well. Things like that do happen. So I wanted to talk about the interpretation of Security Council resolutions, in particular with respect to sanctions, in particular by domestic courts. So this is very, very particular. But this is an area where we are beyond the rules of the Vienna Convention on the Law of Treaties, obviously, and the rules of interpretation there. And I did not want to sort of take up time by discussing interpretation of Security Council resolutions more generally. There have been eminent authorities that have written on this topic, Akis Papastavridis, which is quite a shocker that he's not here, because I thought all aging, middle-aged white Greeks with beards were invited, but apparently not. And he has sort of a beard, and I can be very open to the interpretation of the term beard. It's not clean shaven, that's for sure. And the other one, of course, is Sir Michael Wood, who absolutely does not have a beard, nor would he ever consider that. So I'm not going to take any time trying to discuss this more generally. Rather, I wanted to look at how domestic courts have gone about interpreting sanctions resolutions. And of course, that's double trouble, because not only are we outside the purview of the Vienna Convention in terms of we're interpreting resolutions, so secondary laws, as Kiki said earlier, and not a treaty, but also there's a very well-known sort of complaint against domestic courts in terms of the way that they go about interpreting international law that is before them, even when it is with respect to treaties, let alone when it is with respect to anything else. And sort of my favorite example in that respect is a Greek example, which is the court of first instance of Piraeus, the port of Athens, who had to interpret the term ship in the Convention on Civil Liability for Oil Pollution Damage. And of course, they clearly had no idea. So the whole question was whether a floating storage unit was a ship. And so the convention was applicable. And the convention itself defines the term ship. So probably a clever lawyer found the relevant textbook and copied the page on the definition of ship and how it is interpreted in the convention, VCLT 31.1 and all the rest of it, He submitted it to the court. He made a tiny mistake. Well, he didn't make a mistake, that particular lawyer. The court made a mistake. There are two conventions on the limitation of liability of oil pollution damage. One's from 1969, the other is from 1992, and they were on the same side of the copy. So unfortunately, the Greek court applied the definition in the wrong convention. Oh, well, it happens. They did copy the textbook though, so that was good. So how I proposed, so, this sort of like sets the scene in terms of how difficult this can be. What I would like to do for the rest is basically to take two steps. The first one is to review a little bit and try to group together a few examples of interpretation in scare quotes of Security Council resolutions by domestic courts, or how domestic courts go about them. And the second would be to say a few more general things on interpretive methodology and where the general rules of interpretation fit into the whole story. So to start, with trying to categorize and sort of like demonstrating a few examples of domestic courts going about interpreting Security Council resolutions, I think I should say at the outset two things. The first one is we're in a very complicated area here, as we are whenever a domestic court is interpreting any sort of international law, because that is most usually mediated through domestic law. This is especially the case when it comes to Security Council resolutions. There's huge variety in how those Security Council resolutions can be domesticated, or so how they're mediated, so how they come before the court. So that's the first issue. And the second issue is that I'm adopting a categorization that has been adopted by the ILA study group on the principles of engagement of domestic courts with international law, which roughly introduces the categories, and I'm going to go a little bit into them, but not in full detail, of avoidance, alignment, and contestation. So one standard example of what happens in situations where a Security Council resolution somehow comes before a domestic court is basically avoidance, and this can take two different types. We have what we called in that report evasive avoidance, as in kind of a willful blindness of the court, like we have no idea what you're talking about. And this quite often happens, and there are many examples in which the domestic court will only stick to the domestic implementing measure and will not in any way consider how this may be related to sort of like the remote source, which is or the more remote source, I should say, which is the Security Council resolution. So they're just going to go about interpreting the domestic measure and forget about all of international law, if any. The other is there are circumstances where we have sort of like affirmative contestation, and that means, affirmative avoidance, and that is where effectively the domestic court actually says, well, actually, yes, I do recognize that this is somehow connected to a Security Council resolution. So if I am to interpret the domestic measure properly, I should interpret the Security Council resolution to understand what it means. But then it says something along the lines of, I definitely do not want to do that, so I won't. And there are cases like this. I think Dubsky versus Ireland, which is one of the early Irish cases in the Irish High Court on sanctions, sort of like in the whole Bosporus debacle, there were quite a few of those. That's where the Irish High Court basically said, yeah, absolutely not. I have no idea what that is. So we have cases like this. I'm not going to spend too much time on those because obviously we don't have evidence of interpretation there. What we have is evidence of I either have no idea or I don't want to have an idea. The slightly more interesting category is the category of alignment. So alignment can be quite complicated because first of all, it's a category that flies beneath the radar most of the time when we have what we call fair weather or sort of like everyday alignment, when there is, when domestic courts sort of in a run-of-the-mill case align with international law. nobody really bats an eyelid, and it happens every day whenever there are rules of jurisdiction that are being interpreted or what have you, right? Things like that. I mean, jurisdiction of the state. Things like that mostly do not make the 9 o'clock news. It becomes more interesting when we're talking about overriding alignment. So situations where the domestic court actually overrides domestic law by relying on international law. And we do have examples, and some really interesting examples, where courts have done that on the basis of sanctions and in interesting situations. So one example is actually a Dutch example, which relates to the Al Haramain Foundation, whose assets had been frozen in the context of the 1267, 1899 regime and so on. What used to be the Al-Qaeda, Osama bin Laden, Taliban regime, and is now the Al-Qaeda, ISIS regime. And the Dutch authorities had effectively basically dissolved the foundation. And so the foundation went to court and said, excuse me, guys, but it says freeze my assets. It doesn't say dissolve me as a legal entity and just like eat up my funds. And the Dutch court did take the step of actually interpreting the Security Council resolution and saying, well, yeah, that's what it says. Now, don't expect any detailed analysis of interpretive methodology in the court's thinking here. The court basically just read the resolution and they were like, that's not what it says. So fairly commonsensical. And there are examples like this where indeed the domestic measures go far beyond what the Security Council resolution requires. I mean, states love that, right? So there's a sanction resolution and they're like, okay, so now we can just start hitting those people. Another example is when a Turkish, for example, the Turkish presidential decree implementing the Libyan sanctions, the post-2011 Libyan sanctions, which effectively were targeted sanctions on specific legal entities in Libya, and they weren't even that many. There were 25 or 27 or something like that. And the Turkish presidential decree was like, freeze all the assets and don't pay any funds to any entity incorporated in Libya. And so you would go before the domestic courts, or foundations would go, or other legal entities would go before the domestic court, and they would have to provide all sorts of expert opinions from lawyers saying, you can't say that in your, it's not what the resolution says. How am I doing for time?
10 minutes.
Oh, 10 minutes is all right. So in these situations, we do have overriding alignment, but they are, I mean, most of the cases that I've seen are fairly sort of like open and shut. Quite clearly, the domestic measure was not what the Security Council resolution was saying. And at least here, the court took the step of actually looking at it and saying that's not what it says. Because in cases of avoidance, that will not even come into play. You will stick to the domestic measure alone. There's another category of consubstantial alignment, but I'll save that for now because I need to explain what consubstantial is. And I'll just move to examples of contestation. Again, with contestation, we can have different sort of like examples of contestation. That is effectively where the domestic court is contesting the international rule, but the domestic court may be contesting the international rule sort of like in a negatory way by disregarding it, by saying, okay, I acknowledge that there is an international rule, but I don't like its content, so I'm not going to apply it. And you can say that there are examples like that in interpretation of sanctions resolution. So in particular, Bosporus, before it became Bosporus, so Bosporus before the Irish High Court effectively both had to interpret the domestic measure. Let's just call the EU measure the domestic measure for argument's sake. And it did acknowledge the connection to the Security Council resolution. It did acknowledge that it had to interpret the Security Council resolution. It rejected the interpretation of the Security Council resolution that the Sanctions Committee had put forward and adopted its own interpretation of the Security Council resolution, applying roughly domestic law interpretive methodology. They said, well, this is how we interpret Irish law. When we apply this to the resolution, this is the outcome. They came to the completely opposite outcome than the sanctions committee had come up with, and this is how the whole thing progressed. Obviously, they were overruled, and obviously, then European Court of Human Rights and what have you, and that story is known. This is one example, but again, the more interesting example here is consubstantial contestation, and consubstantial alignment and consubstantial contestation can be quite close. So perhaps I should explain those terms, which sound a little bit like well, either Althusserian or religious, if you're Greek Orthodox, depending on how you want to go. I have a beard, so I can play on both sides. And effectively what that means is when you have something akin to what Yuval Shani, for example, and others have called multi-source equivalent norms. And here we're not talking about different sources, but we're talking about legal systems. So you can have equivalent norms in different legal orders or self-proclaimed legal orders. So for example, we've heard about the fair trial rights or the right to a remedy. Now, obviously, fair trial rights exist at the international level under many treaties and customary international law, but at the same time, they do exist in most constitutional legal orders that we know that is one of the fundamental rights. So the question becomes, what happens when effectively the domestic court is either aligning or proclaiming to align itself or contesting an international rule based on a domestic rule which has an equivalent in the international legal order? And there you can classify those as either consubstantial alignment, because after all, the court is interpreting the law and aligning with international law in its interpretation, even though only consubstantially. In the other case, you could say it is contesting one rule based on another rule of international law, based on another international rule, though not directly, by reference to its equivalent domestic norm. I hope that makes sense. It has to do with the fact that we don't actually know what the law says, because I can tell you what I think the law says, but that doesn't really matter. That's not necessarily what the law says. What the law says is what the authoritative entity for determining what the law says would say. So in that case, you know, it's like we can ask Judge Ziemelin, she can tell us, and then that will make sense when she's acting for the court, right? But for me or you or Panos, sorry Panos, it doesn't really matter. So it can be either, is what I'm trying to say. And here we have examples, and they're well-known examples to some extent. One is Abdelrazik before the Canadian Supreme Court. And another is, I'm not going to go into Cadi, even though we can consider, based on its own determination of itself, we can consider European courts to be domestic courts, right? Ordre juridique propre. If you want your own special legal order, you're a domestic court as far as the international lawyers are concerned. But we can stick to Ahmed in the UK Supreme Court. And in both those cases, effectively what happened was the domestic court realized that if it had to interpret at the international level, so acknowledge the connection with the Security Council resolution, then effectively it would be in a bind where it would have to go along the lines of Article 25 UN Charter, Article 103 UN Charter, nothing else matters, end of story. So instead of doing that, they said, we're going to review this at the lower level. We're going to review the domestic implementing measure as opposed to domestic constitutional law. But effectively, both of these have their reflection at the international level in the Security Council resolution, which was properly implemented in those cases. It isn't that there was some absurd misreading of the resolution, and obviously international human rights. So the court in Abdelrazik, which basically had to do with the refusal of Canada to allow a national to return to Canada, pretty much said, this cannot be what the Security Council resolution meant. And in any event, this person needs to be able to return to Canada because he's a Canadian national, and there is a right to freedom of movement, which includes the right to return to your home state. So Canada must give him a passport so that he can return. And in doing this, the Canadian Supreme Court is one of the few instances where you can see the consubstantiality working, because they said, well, this is under the Canadian Charter of Rights, but of course the Canadian Charter of Rights reflects the customary obligations under international law, ICCPR. The similar thing can be said about Ahmed. The link there is the connection to obviously the rights to a fair trial. I'm not going to take any more time with that because I only have 2 minutes and I need to rant. So if you all permit me, I mean, what we've seen throughout this is you don't see the domestic courts coming up with any sort of like refined methodological approaches to how do we interpret Security Council resolutions. Do we go by some equivalent of the general rule of interpretation in 31? Do we go by some other rules? Do we apply domestic rules and all the rest of it? And you can say, well, that's a problem. Isn't that terrible? How are we going to make any sense of this? You know, now that we have lost the shining beacon of Articles 31 and 32 of the Vienna Convention that really guide our interpretation and so on and so forth. And what I would like to say, and this is my rant, so just bear with me for a few seconds, is you don't need to fret, I think. And you don't need to fret, I think, because as should have become evident today, as was even evident in Kiki's talk just now, these rules actually tell you nothing other than use methods of interpretation. I mean, look at it. Article 31 tells you text, context, object and purpose in good faith. Shocker, really? So textual, contextual, and teleological or purpose of interpretation, because after all, a purpose is an end, is a telos, is a, you know, that's the whole point. I mean, that's how I understand it. So text, context, object and purpose, the standard methods of interpretation, plus historical interpretation, in Article 32. Oh, but you can't always go there because the meaning needs to be absurd or whatever. No, you can always go there to confirm the meaning from Article 31. And of course, we all know that you can go there before you reach the meaning under Article 31 and so on. So these are the standards method of interpretation of all law. And the interesting thing is that the Vienna Convention, the ILC itself, doesn't tell you how to use them. It just says, oh, you just throw them all in a crucible and you crush them. And whatever comes out is the interpretation. And the question then becomes, I mean, I don't know. I'm not very good at cooking. I only cook 2 dishes. That's about it. But I imagine that if some of you who do cook got a recipe that said you need to throw in meat and red wine and salt and eggs, and that's all it said, right? Every outcome would be different because it doesn't tell you how much text, how much context, how much object and purpose, nothing like this, right? So these rules actually only serve as a confirmation of whatever interpretation the authoritative interpreter reaches. They actually give you no guidance. And if you saw what Kiki was talking about earlier, she was talking about sort of like how much object and purpose should we give the constitutive instrument, whereas in secondary law, we should probably have a little bit less, or people say less object and purpose, but more context. Whereas if you look at what the WTO dispute settlement body does, is it opens the Oxford English Dictionary and it says, no, I'll just give you like about 2 pounds of text before we do anything else. And it makes perfect sense. And all of this is allowed under the Vienna Convention rules. So the point is, I think my understanding is that to some extent, these things serve as an incantation, right? It's sort of like, as long as you chant the incantation, everything's fine. As long as you say, in accordance with Article 31, I'm finishing, in accordance with Article 31, of the Vienna Convention, blah, 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 blah. The incantation has been sung, so everything's hunky-dory. Whereas if you're in a domestic court and they, God forbid, use some unknown incantation, it's like the religions of the book, right? They all have the same book. They still kill each other, even though it's because the incantation's a bit different. So if you use another incantation, or God forbid, you don't use an incantation, then we're all freaking out about how was this interpreted? What methodology did you use? The methodology is always the same. And that is, there's some text, some context, some object and purpose, a little bit of history, and basically the cook is allowed to make do in the kitchen. Thank you very much. Thank you for your patience.
Thanks very much for that metaphor of the cook and the ingredients, rules of interpretation as ingredients for a nice recipe. So from the General Assembly, the Security Council, we're moving to the more general, or maybe to the ILC, I don't know. But we're very happy to have Professor Vidmar Jure from Maastricht with us. And he's going to speak about, well, the title here is Rules of Interpretation Outside of Treaty Law, but more particularly, it will be about general principles of law and jus cogens and the place and role of these concepts when viewed from the perspective of the principle of systemic integration. The floor is yours.
Yeah, thank you very much, Larissa, for the floor. Also, I would like to thank the organizers for inviting me to take part in this discussion. I'm especially honored to be here because I'm very fond of the TRICI-Law project and the important doctrinal work it has done and is still doing on the rules of interpretation. So maybe because I do not understand Greek, I can understand the articles more, or the pieces more than Elias can. But then indeed the work that the TRICI-Law project has done also narrows down quite a bit the topics that are still available to me within this broader umbrella of interpretation rules beyond treaty law. So I will just say that I subscribe to a great deal of what Panos and the whole team have said about the rules of interpretation concerning custom. And I also subscribe to a great deal of what Antonios just said about the rules on interpretation in the Vienna Convention in general. But I will then primarily focus on certain other rules of international law that are even more mysterious than customs, so the general principles of law and jus cogens. And I will look at that through the, or consider particularly their function in the interpretative method commonly called systemic integration of international law, which is of course most famously reflected in Article 31, 3C of the Vienna Convention, but also does have life outside of the VCLT and outside of the Vienna Convention and outside of treaty law in general. Now, general principles and systemic integration are indeed quite closely linked. And here I need to refer again to Panos Merkouris for his excellent analysis in one of his pieces available online on the work in papers projects on the drafting history of Article 31, 3C VCLT, and in which he demonstrates how general principles indeed played a very central role in the drafting process of this provision, much more prominent than the final text would perhaps suggest. But the question is, what should we even expect of systemic integration? And once again, I cannot avoid Groningen's scholarship, because in her 2017 ICLQ article, Mandó-Rakovica demonstrates that systemic integration shouldn't be seen as a panacea that solves all the conceptual problems that international law has, so that we should not expect too much. So it creates also its own problems, and its purpose should not be, or what we should not expect is some kind of a perfect harmonious unity of all treaties, or indeed of perhaps even all sources of international law. And as it was very aptly noted in the ILC's fragmentation report, the international legal system has never enjoyed the kind of coherence that may have characterized the legal orders of states. Now, we cannot, of course, expect that systemic integration would fix this problem, this problem with the lack of coherence, and turn international law in a legal system that would work very much like what we are used to seeing in domestic legal systems. But some scholars, and then also the ILC in some of its subsequent work, found that at least a basic idea of such a coherence in general principles and which have been labeled in some works as systemic officials or systemic elements of international law. And the need for this role of general principles, I think, stems from the conceptual nature of public international law, namely that despite its name, public international law, there actually is not that much public law in it. And general principles of law then provide for at least some very elementary public law framework on which we can rely. Then some have thus called general principles structural, or so that general principles have structural or even constitutional function, but not in the sense, so constitutional, not in the sense that they would have hierarchically superior status that constitutional rules would have domestically, but in the sense they provide for a sort of a systemic umbrella for the interpretation and application of private law type international legal obligations. Now to illustrate, so general principles have been quite important, for example, in the context of ancillary procedural issues of international or in international adjudication. Say when states create an international court or tribunal, the drafters of the treaty provisions cannot foresee in the treaty text all possible ancillary procedural issues that may someday arise in the procedure before the court, and then solve all these issues up front in the treaty itself. It is then essential that international adjudication adopts what some have called general principles of procedural law, and that these are then integrated with the provisions of the treaty that has created the court. But the problem then of systemic integration in the end is that the result depends on who is interpreting and who is systemically integrated. And then when it comes to authoritative judicial interpretation, the result will then often depend on which court, tribunal, or quasi-judicial body you ask. So some would then criticize that systemic integration then works in favor of those specialized regimes, the constitutive treaties of which have created judicial bodies, possibly even with compulsory jurisdiction, so that there is a lot of case law coming from those courts. And then we may actually get systemic functional bias rather than systemic integration proper. And then here we come again then, I think, to the problem of a lack of public law in public international law, because international adjudication is a dispute settlement mechanism. It has the goals of dispute settlement. Judicial bodies are created sort of contractually by treaties, and jurisdiction depends on state consent. Now, compared to domestic settings, the nature of international adjudication can thus fall much closer to private arbitration than to comprehensive structure of the judiciary in domestic legal systems with the constitutional review on the top. And so we structurally, again, cannot expect a great deal of systemic coherence internationally or from international adjudication. And this is the structural problem, not the problem of those those judicial bodies. I therefore agree with those who say that systemic integration should not be seen or it should not be expected to be a panacea. And the lack of public international law is such that coherence is lacking, and we are operating in essentially in a private law paradigm. But then general principles of law do what some have called fill some gaps and provide for some rudimentary systemic structure, as has also been now confirmed by the International Law Commission on its work on general principles. And now I will turn to another controversial concept. So the rules of jus cogens, which have also been under some, received some scrutiny from the ILC. And now, but first linking the concept to what I have established just now about systemic deficiencies of international law, it appears that jus cogens in fact also plays a systemic role and contributes to this rudimentary public law umbrella in the inherently private law design of public international law. Now, if we first going step by step, first if we look at the generally agreed list of jus cogens norms, we see that there are mainly prohibitions of something. So there may be a couple of exceptions, such as the right of self-determination, but even there, I think I would not say it is the whole normative content of common Article 1 of the covenants that is actually covered by the jus cogens character. Now, especially if you think of internal self-determination and what that may entail. I think even with the right of self-determination, it is, in my view, what is covered by the by this peremptory character is prohibition of colonialism and prohibition of colonial exploitation. So indeed, if we look at the jus cogens norms, we always end up with prohibitions of something, with prohibitions of certain conduct, with prohibitions, I could even say, of certain action. We do not really, it does not extend to really to positive obligations and omissions. Now, generally speaking, of course, the scope of the underlying norm may be broader than merely the prohibition, but the jus cogens character would not really seem to look beyond that. Say, if you look at the freedom from torture, the obligation, so the obligations are of course broader than the negative obligation to abstain from torture, but the peremptory norm would say, but the peremptory character would, for example, not waive immunities of the torturer or create a right to a court where such a right would not exist otherwise. Now, this narrow interpretation, of course, is not accepted by everyone and not by all courts. Say the Italian courts may have a bit different views on that, but general doctrine appears to be that jus cogens should be interpreted rather narrowly and not with really extended to the so-called secondary effects. So it does not override immunities, does not create remedies, and one could even say that it has that the effet utile of jus cogens is rather limited. And this leads us then to the question of what does jus cogens actually even do? And here, well, we are then back to Article 5 to the Vienna Convention, the Law of Treaties, and this time to Article 53, which says that the treaty is void when it conflicts with jus cogens. And now my first observation here is that the VCLT, in doing so, accepts that treaty could be voided by certain rules that exist outside of treaty law. So that this is then another example of the VCLT taking into account other relevant rules of international law applicable between the parties. So, which was a wording of Article 31(3)(c). So we can say that Article 53 may be seen as a sort of a subvariant of 31(3)(c). And at the same time, if we know how narrow the scope of jus cogens character is, or how narrowly it is interpreted, how likely it is actually that a treaty would ever, or in practice, conflict with it. So if two states wanted to torture you, they probably would not formalize that in a treaty, they would just do it. But Article 53 is there, and it does have, I think, an important function. It prevents that certain kinds of treaties come into existence and that certain kinds of obligations could be created. And in the sense then, the rules of jus cogens represent what we would domestically call public law limitations on the freedom of contract. So that certain obligations cannot be created because the actors, between the actors inter se, because such an obligations would offend against the public order. So we come then back to this. It is what we have in jus cogens is the minimum threshold of international public order. And international law, so does adopt this idea, I think, of this public order, and that there are certain kinds of obligations cannot go against this public order, but very prominently in treaty law, but it is not limited to the Vienna Convention and to the to treaty law. It also works in customary international law, which now I'm glad that this has been specifically invoked also by the in the ILC's work on jus cogens, because jus cogens also prevents that the contrary obligation could emerge under custom. It's more in the EU law language. We could say that jus cogens occupies the field. So then custom could not go and develop there. Say, for example, an obligation to torture, to extract information to save lives in a ticking bomb scenario, which was at some point advocated by some, could not develop under custom because the jus cogens prohibition of torture stands in its way. Say, even if we got state practice in support of such an obligation, there could be no opinio juris because there can be no belief that violating jus cogens is required by law. So we can say then that jus cogens provides for another systemic element into the design of public international law, although the scope of norms appears to be quite narrow for the time being, interpreted narrowly at the moment. And the peremptory character only extends to the prohibition. And the norms then effectively function as kind of a public law public law limitations or minimum threshold of international public order and obligations that are created by the actors can, in their private relations, inter se, cannot offend against that public order. And as such, I think they also shape the interpretation of other rules and the scope of other international legal obligations. Now, because my time will be up fairly soon, if I start summing up, general principles of law and jus cogens, I think, have a systemic function in this non-constitutionalized, non-hierarchical system that is more inspired by private law than public law principles. It may be sometimes indeed in practice difficult to discern a concrete legal obligation directly from a general principle of law only, so if not in parallel with some treaty provisions or not in parallel with customs, so out of general principle alone. And at the same time, the effet utile of jus cogens may well be very limited, but the concepts, I think, are both of systemic and structural nature because they sort of provide for the systemic glue of the international system and sort of, so to say, the interpretative sandpaper that shapes international legal obligations stemming also from other sources. And they also ensure, as I've demonstrated, I hope that certain obligations cannot and do not develop. And in that sense, they're not only instrumental in determining how certain rules should be interpreted, but also how they should not be interpreted. So now in the end, I think I will say that indeed, systemic integration is no panacea of international law. It does not turn international law in a comprehensive, constitutionalized legal system, but the rules of international law are interpreted in line with some basic systemic requirements. And general principles of law and Jus Cogens rules are part of this systemic structure. And this then, in the end, attests to the fact that systemic integration and systemic thinking in international law more generally did not start and do not end with Article 31(3)(c) of the VCLT, and that rather this treaty provision is a consequence and a reflection of certain systemic elements that actually exist outside of treaty law, but they do affect also treaty interpretation. Thank you.
Thank you. Thank you very much, Jure. I think this was very valuable contribution to the project, engaging with the work of the project, moving us beyond customary international law also. So I think I'm going to open up the floor. I do think actually from all the presentations that, so we're talking about rules of interpretation and the ingredients, but we might also need to talk about the cook. So the interpreter. We have talked about the judge, we have talked about academics, now we bring in domestic courts and states, but of course, in particular, when we talk about sanctions, we also see private actors interpreting. So we might need to think a little bit more about the person of the cook and maybe also the kitchen. So then again, you were referring to the sanctions committee and as some kind of intermediate interpreters offering authoritative interpretations that are then deviated from. So what are the safeguards of against undesired interpretive dynamics? And should we not also think about, the kitchen or the interpretive architecture, in particular when we talk about institutional environments? So just some thoughts to open the floor actually for you to bring some thoughts back to the panel. Yeah, André.
Thank you, André de Hoog, University of Groningen. Antonios, I'm going to give you a rant back. I think you're completely mistaken. When Articles 31 and 33 were being deliberated, especially at the Vienna Conference, 1968, the Americans precisely tried to argue what you did. Just list the elements and, let the interpreter just pick and choose and see what comes out. But that was rejected. It was rejected by the conference. Of course, the commentaries already indicated that the text is the common intentions of the parties, reflects the common intentions of the parties. The International Law Commission in the commentary also talked about the legally correct interpretation, which suggests there is a kind of at least ideal interpretation somewhere. And you're kind of, when you think in terms of these elements, there is weightings in the text. Article 31 opens by saying that you shall interpret in accordance with the ordinary meaning in context, but only in the light of the object and purpose, which means not in accordance with the object and purpose per se. So the purely teleological interpretations are precisely rejected by that formulation. So I don't think you can simply say that. I know that Daniel Pete has a very different opinion. He kind of thinks they don't impose obligations at all. So that's kind of perhaps in accordance with you. Of course, this doesn't predetermine the exact interpretations of the text, even if you apply these weightings. But to say simply, that we throw it in the crucible, which by the way, is a melting pot in which you most of the time actually melt metals rather than ingredients. Just throwing it in the crucible is not what Article 31 is about. It's about systematically using these elements to make sure that you have a complete picture of all the issues that arise. But there are also some weightings in the text. Everybody seems to want to ignore that, but they are there, and you should actually pay attention to that.
Thank you. I'm looking around. Yes, panels.
Thank you all very much. If it's okay, I have a question for each of the panelists. Kiki, one question, because you mentioned that teleological interpretation would end up creating a new rule. And I'm not sure that I follow the logic there, especially with customary international law. I mean, if you were going to say that, then you would have, I presume, to take the same opinion with respect to treaties. Right, that any kind of teleological interpretation would essentially create a new rule. And international courts have been consistent that, you know, we remain within the boundaries of what the rule allows us. So that's where I would kind of say that teleology does not necessarily, it simply, you know, maybe expands the scope to areas where it is permitted or not. But I'd like to hear your thoughts on the matter. Jure, with respect to use cogens, what I would be interested in are your thoughts, because the ILC in its conclusion seems to be leaving open the possibility of an emerging later use cogens rule. But the way you described it, because it acts as a bar to customary international, to state practice and opinion juris, so it immediately becomes null and void. So would you say that the ILC went wrong in that direction, that it makes sense from a theoretical perspective, or from a practical perspective, it is impossible to happen? Or is there a loophole there, you think, that in a weird, very weird scenario, this might arise, so you could have a later use cogens rule in direct conflict? And Antonis, I can't believe that I'm going to say this. I had a question about reverse consistent interpretation now, and I'm going to, can we shut off the cameras? Because I don't want anybody to hear me saying this, that I agree with part of your rant. Surprisingly so. Surprisingly, it's where Andrea was commenting. I completely agree with you about the relationship between 31 and 32. For me, it doesn't make sense. I think it is bad drafting on the part of the BCLT. Courts and tribunals go at it whenever they want, and also the way it is described and the choice of words as supplementary means and not secondary, which was originally proposed. And by the way, it was not just the United States, it was Greece as well that proposed it. As one article, well, but we might be biased because of that. No, but the way it is described as confirmatory or determinative, then absolutely you can always go there. Where I will disagree with you is on, first of all, on the image of the crucible, that it is about smashing. It is a nice image, but it is a destructive image, and the crucible actually is about melting things and making them into one. So it's a more of a harmonious image rather than a crushing image. The second one, and I take it from your admission that you can't cook more than 2 foods, right? Types of food. So then you said, well, I give you ingredients and then you can do no instructions or little instructions, and then different things might appear. Yes. And if I give you ingredients and very few instructions and you cook, and the cook that will cook us, the chef that will cook us dinner tonight, most likely, most of us will like the recipe of the professional cook who has an understanding of the rules, of the connections between the elements. And it might be a little bit intangible. And this ties to what Larissa was saying, that basically we have to look at the cook, we have to look at the kitchen, at the tools, at everything. So I do think that the discussion, the rules make sense, because also it takes out stuff, or at least it gives less value. Plus the further discussion, irrespective of whether it is non-ending or whether, like me, you're a Platonist, or like you simply reject the importance of the rules of interpretation, that it does help in providing at least some guidance as to the weighting. How much guidance? It depends on how precise the rules, and that's exactly why we were having this discussion. So
it's a 2-finger from Judge Zimmerman, I think.
Yeah, just a little bit to continue on this, and also to probably tie into Professor Brölmann's possible reply to the question. In fact, to absolutely confirm, and Antonius, I'm sorry, I'm going to disagree with you. But I would like to come back to the importance for the legal system of legal certainty, and that certainly is how the courts do see the general rule of interpretation. Yes, going along the lines of how I'll see conceived of it and how the Vienna Convention was adopted. We may or may not like it, but I do, well, in a way, insist that that systemic element for a legal order is very necessary. Otherwise, we can close the shop and go home, you know, and forget about it. That's the first point I wanted to reiterate, and that's where I started in the morning. And actually, the panel really brings back to what we have been discussing the whole day, because it is, and that comes back to your comment on the relationship between the so-called teleological interpretation and the creation of new custom. Because when you look at the case law of the European Court of Human Rights and the criticism I mentioned early in the morning, that is exactly on that point. So when the European Court of Human Rights, in fact, goes into Article 31(3), B and C, in fact, and when the court looks into, you know, what it calls sort of the subsequent practice of the states, just, I'm not even going into living instrument or evaluative interpretation, but subsequent practice, and draws conclusions from that. And indeed, actually, as I mentioned, expands, well, go back to Golder versus United Kingdom, expands on the text of the convention because there is a practice, state practice. Now, my question has been, I have asked, you know, we've had really interesting discussions back those days in the Strasbourg court, but is it really just the subsequent practice element in the interpretation, or it is the establishment of the existence of the regional customary rule? You see, that is the issue. And on that, in fact, we are moot. We don't really have a clear answer. You see, and actually it links into what Jure was then, you know, talking about. So are we really clear that we have applied the method of interpretation, have just established subsequent practice, or are we, you know, in the other rules applicable, and we have in that established a new customary rule on a number of issues? And so this distinction between B and C, in fact, is very important. And that is what instructs, are we really with, you know, evaluative interpretation, teleological interpretation? And so if you would pick up on that, I would be really grateful.
I propose we do Celine and Marcel, and then we go back to the panel.
I withdraw my question.
Oh, okay. Yes,
We,
please.
no,
No,
okay.
I think it's so that we can handle
Okay.
it.
I have actually a question for Kiki. I know that I understand that your assignment today was to look at the UN General Assembly, but I would like to pick your brain on actually a smaller context. If you use your starting question to, for instance, an institutional context, which has a more specific mandate and personality in particular, which can be more easily anthropomorphized. And in my mind, I had the UNHCR and the role of the High Commissioner for Refugees, and how over the years, the interpretation of its own mandate on the basis of the convention has been expanded to displaced persons already in the 60s and 70s, thanks to the work of the High Commissioner at the time, Aga Khan, and then how they also worked on well, the content, the scope of application, and the nature of the principle of non-refoulement through the executive committee over the years. And there, I mean, I could see an opinion juris of the UNHCR emerging. But yeah, it was just to pick your brain on a smaller setting. Thank you.
Would you like to go first?
Yes. Yes, well, thanks. That maybe I start with the last good, because actually you allow me to pick your brain now. That's the elegant, notwithstanding the elegant way in which you offered. So I think yes, it would. So I must also confess that the request to me was not to look at the UNGA. That was my too hasty methodological decision. And then halfway, I realized that it might not be the best parcours to take. So this is actually, and it's interesting that you say that can be anthropomorphized more, because that might actually be helpful here indeed. And there's of course a certain, sadly enough, continuity in the facts and a certain and a solid diachronical aspect, because there, as you said, it is since Aga Khan already there has been these legal practices. So it might be an excellent field indeed to look at. So yeah, thanks a lot. It's a very good idea. Then I don't, if you allow me, I don't take the order, because actually maybe I do, and I confess that that maybe you can repeat the exact point that you wanted to propose to me, because I was all engrossed in the story, and then so now I'm not sure what angle to take to give a concise. So it's a bit connected to what Panos is saying. Okay, but that I have a clear view on, which I will now share with you. So the point I was trying to make or aiming to make is that, of course, there is a difference with teleological interpretation of a treaty provision, because there you have a text, the text which is the lex firma, and then, of course, the implication of teleological interpretation is that it goes a bit beyond the actual text. That is a bit the touch, the flavor, no? But in case of a customary rule, which is of course unwritten, an interpretation that would change a bit the previously assumed content of the rule would create it. That would be a case of our paragraph 186, no, in the Nicaragua case. I mean, it would create a new rule. Mm-hmm. So the way I see it, it's more of a conceptual, like a logical fallacy. It cannot exist, because there is not this written provision that sort of holds back. So you don't get this contrast that you get with evaluative interpretation and teleological. So I thought actually that was what Ilias was saying, and I thought it was very smart. So that, and if you have one more minute, because of course I need to respond to the cook, and so I have my own rant also, and so I first of all I totally agree, and of course it goes for many provisions, I guess, that you can't really know how, when you throw it all together, how it will turn out. And in this case, the ILC has been honest about it with this. It's an art, not a science, or this commentary. However, where I do not agree is that it's precisely as you say. It is a matter of incantation. It's all the law is in our heads. I mean, so they are speech acts. So if you keep saying no, but we need to interpret this teleologically, like with constitutive treaties of organizations, in the end, we believe it. It's like, no, I'm not the continuation of the state. I'm this legal successor. Okay, now everybody's just sitting there. Okay, well, no, not okay. I mean, it all happens here, you know. So the fact that we, at some point, run around rather with cookbooks of Ottolenghi than of, I don't know. I'm not a great cook, so there's no other name that comes to mind. But of course, there is a. So it's true what you're saying, but then there's a next layer built upon that, which of course in itself is norm creating. So there, I really don't I don't want this the dystopian image of this pen where everything is crushed. I mean, there's a next layer.
Dystopian. That's not what I meant by it.
But I thought maybe first
Yeah.
Jure, and then I'll give you the last. I thought that was be appropriate for you.
Yeah, this made everybody really scared.
Yeah, sorry. You maybe agree, Jure.
Yeah, thank you. So I will address what Panos asked directly, what followed out of my paper. So that, and indeed, I think you're quite right that the ILC said that new use-Cogens norms could emerge. It said that that even the use-Cogens norms could be modified. And that is also acknowledged in the Vienna Convention, that there could be eventually new norms. And of course, then I see no problem with the fact that there could be new norms that are not in existence now, and even the list is not it's an open-ended list, and there is no, though there is some identification in the annex of the ILC work, but then there is no document that would say, okay, these are use-Cogens norms, and that's it. So there can be some interpretations which norms have actually acquired this status. So I see no problem in that new norms of this status could emerge and could be added to this so-called list. Now, more of a doctrinal question is, could a new rule of use-Cogens emerge that would be exactly the opposite than the existing one? And that is, I think, first of all, this is perhaps merely a theoretical question, because if nothing else, it would be quite unethical if we reverted and say, well, now there is prohibition of torture, but then as of I don't know, next year there will be actually an obligation to torture, and I think this is not likely to happen, that would acquire use-Cogens status. So I think it is more likely that what could happen, that there would be modification of the scope, but not that there would be a direct that would be obligation to the contrary. And then again, we would, if you then look also from this perspective, again from what how use-Cogens norms are defined, there are always prohibitions of something. So you need to abstain from torture. You need to we are talking about prohibitions. And then, and this also then kind of narrows the possibility that there would be actually an obligation to do, to engage in a contrary behavior. But then at the end, if we also look at the, from the perspective of custom, of course, there's also, questioning customary international law. Didn't actually a lot of custom develop by certain practice that was at the time when it first emerged violation of existing custom? Of course, we could debate about that theoretically, but I think what is crucial here is that we indeed, with a use-Cogens scope, we have prohibitions of something, which would then I think prevent that there we would, from a prohibition, from peremptory prohibition, that we would actually get a peremptory obligation to do the contrary. So that would be my answer to that.
Thanks for that, Jure. I agree with you that we have tired the metaphor of the cook, but we do have the bartender waiting for us, a real one. But I'm going to give you the floor first. Sorry.
All right, well, as the only thing standing between you and drinks, first of all, thanks very much for, even if tiring the metaphor, I did think it's working very well. Well done. Point one. Point two is thank you for engaging. And I'm happy that people disagree. I'd be happier if they agreed, but then I'd probably be doing something wrong. Three, I did have the term mush rather than crush in my notes. I don't think if that makes any difference cooking wise, but
it's not about cooking. It's about melting metal. You're mixing metal.
Melting and mushing anyway. Right, you go melt your melt your metals while I present something different. So it's been a lot of comments. First of all, let me start by saying I don't think that we disagree, Kiki. I think we agree completely, because it's precisely what I'm saying. And that's precisely what's causing people to get pissed off at what I say, which is that in the end, you end up believing the incantation. I mean, that's a whole concept of religion, right? You believe the incantation. But here's the thing. The thing is precisely that I'm not saying that you're not creating something. Of course, you're creating something. That is the point. Let me try and start from the beginning very, very briefly and present it, and then we can all go for drinks and never talk about this again. But I think that there is this whole idea that somehow the Vienna Convention provides some guidance. Yes, it provides minimal guidance. That's what I'm trying to say. It just tells you use the same interpretive methods that we use for all law, right? That's what it says. Now, to try and grasp at straws a little bit, and sorry for saying that it says in accordance with the text, but in light of the object and purpose, and only in the context. I don't think that helps. And I don't think that helps because, and I don't want to Derrida the life out of you, but you know, il n'y a pas de haut text, there is no text without context, and what does it mean in light of the object and purpose? And isn't the object and purpose text itself? Because otherwise, how do you find anything without text? Even custom is text in your head. Everything is text because you speak in text. There is no other way to communicate. You don't communicate by drawing images on the wall anymore. And so by that sense, everything is text. So of course you're going to start with the text because that's how your brain works, right? And I don't even want to take it before, I don't know. This is Panos is 4-month-old, doesn't yet speak in text. When he starts speaking in text, when he starts thinking in text, that's the root of all his psychological problems later in life. All right? It's not me, it's psychologists that say that, or psychoanalysts rather. So that's the first point. The second point that comes from this is precisely the point of the incantation. So there are people who are archaeologists of law who say there is one true meaning to the provision, and what we need to do is to use the rules that have been given to us, so the guidance, for us to go and find the one true meaning of the law. I do not subscribe. It's okay if you subscribe to this. I just can't subscribe to this because I do think, per Kelsen, every rule has a range of plausible interpretation. All the plausible interpretations are correct. They're not wrong. All the foods that we make with the ingredients, Panos, they're not wrong. They may taste. No, but you said, assuming that they're not ingredients that will do that. But the point is, yeah, obviously, if I give you cyanide, yes, but that's not the point. The point is, and let's not tire this any longer. The point is that with normal ingredients, no food is wrong. You may like it more or less. And that's what you said. You said if you give it to a professional, the professional will make something that you like. Whereas if you give it to you, Antonius, who don't know, sort of like your elbow from, I don't want to say, what? Then what you make, people won't like. That's fine. It won't be wrong. It's just. Yes, there are standards, but that's exactly, but the standard for plausibility is text, context, object, and purpose, and that's so broad that it's only ridiculous interpretations that are implausible. Within the range of plausibility, there are different interpretations which are plausible, and they may be more or less plausible, but they're not implausible, and they are all in line with the incantation. And what shocks you, Andre, and many other people, and that's why we have all this debate, is that by saying that, we are exposing that the selection between the foods that you like and the foods that you don't like, between the interpretations that you like and the interpretations that you don't like, is a political decision. And it is a political decision. And once this is exposed, people start getting shaky because they're like, oh my God, what just happened to legal certainty? Well, nothing happened to legal certainty. Legal certainty is political certainty. We all have political biases. We decide, we find this more plausible than that, but that's why the legal system, right? And again, per Kelsen, has created one authoritative interpreter for the rule. I may think, and I said it in my speech, I may think that this is the content of the rule. You may think something different. In the final analysis, it doesn't matter what any of us thinks. What matters is what Judge Yemele thinks when she sits as a judge. That's the political decision that is given by the law authoritative power. End of story. It is her political decision. Why? Not because we prefer her political positions to mine, but it is because the legal system put her in that position. In international law, which is a decentralized system, it gets a little bit more complicated when you don't have to go to a judge, but this is, yes, judge. But this is how it is. And I submit to authority.
This is the correct interpretation.
Well, this is the authoritative interpretation.
Thank you, thank you. You see that academics need judges, not only for interpretation, but also for chairing a panel. So thank you very much. Our panel was in the middle. It was number 3 of 5 panels, and I think it has been quite central and essential for all the other panels. So I think we are into core discussions that we can then continue with the bartender. So thanks very much for our panelists.